Tēnā koutou, tēnā koutou, tēnā koutou katoa, and good evening everybody. It's my pleasure on behalf of the Faculty of Law and on our Dean and PVC, Professor Mark Hickford, who unfortunately can't be here tonight, to welcome you to the Law School and to the 2019 Law Foundation Distinguishing Visiting Fellow Lecture on the Digital Revolution, the Rule of Law, and the relevance of the judiciary to society. To be given tonight by the Right Honourable Lord Thomas of Cwmgiedd, I hope. Lord Thomas, of course, has a long and distinguished legal career. He read law at Trinity Hall, Cambridge, and then the University of Chicago before being called to the bar at Gray's Inn. He practiced at the Commercial Bar in London from 1972 to 1996, taking silk in 1984, and was appointed to the High Court of England and Wales in 1996. Lord Thomas was successively a presiding judge in Wales from 1972 to 1996. He was appointed to the High Court of England and Wales in 1996. I've repeated myself here. Lord Justice of Appeal, President of the Queen's Bench Division, and finally the Lord Chief Justice of England and Wales between 2013 and 2017. Lord Thomas has been keeping himself busy in a wide range of other things. He was founder of the European Network of Councils for the Judiciary and its president from 2008 to 2010. He is currently chairman of the Commission on Justice in Wales, chairman of the London Financial Markets Law Committee, and president of the Qatar International Court and Dispute Resolution Centre, and also sits in the House of Lords. Since his retirement as Lord Chief Justice, he has returned to Essex Court Chambers and practices as an arbitrator. He is Chancellor of Aberystwyth University and an honorary fellow of a number of other universities, and a founding member of the European Law Institute and currently a member of its executive committee. Ladies and gentlemen, please welcome Lord Thomas to give tonight's lecture. Thank you very much for listening.
May I first say what a great pleasure and privilege it is to be here and to have been awarded this fellowship to come. And the subject which I've chosen, although inevitably I have to draw on my experience of the United Kingdom, or should I narrow it down slightly to England and Wales, the subjects are, I think, ones of profound interest, because whatever view you take of the digital revolution, the rule of law, and why judges are relevant to anyone, these are universal issues. And so I thought it would be useful, rather than dealing with too many issues relating to the technicalities of the digital revolution, to stand back and look at things more broadly. And where I'd like to begin is with the rule of law. To most people, obviously no one in this audience, the rule of law is one of those subjects which is not really understood. It's a subject of endless fascination for lawyers, but for few other people. It only rarely gets into the newspapers in the UK. It got into the newspapers a bit earlier this year when Lord Neuberger said that the lack of legal aid was a potential threat to the rule of law. And when you talk of threats to the rule of law, that is if the heavens are about to fall in. And of course, the current problems relating to Brexit, again, have emphasized the rule of law. But to show how little it is understood, the BBC in its website had an explanation of what the rule of law was. Because, as I think Jonathan Sumption said in his Reith lectures, it's a cliche of modern life that tends to be used without really understanding what is meant by it. Now, I do not intend, because no one could surpass Tom Bingham in his description of the rule of law, to attempt a description of it. And I don't believe anyone has done any better than him, although lawyers have tried from time to time to do so, and the Council of Europe, the Venice Commission, and others attempt this. But what I think it matters to most people really are making certain that the government acts in accordance with and subject to the rule of law, that there's legal certainty, that there is provision for access to justice before independent courts, and equality before the law. And I mention those last two because those are central to what I want to speak about, particularly access to justice and the necessity for equality before the law. Now, although one can discuss what the rule of law means and in more detail, I think most people these days who think about it do accept that it provides for us an essential framework for our society. It enables disputes, or should enable disputes, to be resolved according to a system that is fair, and also to an extent, though not as much as I think many would hope, for disputes between nations. There's no doubt if you come from London and have anything to do with its financial markets, the rule of law is trumpeted as one of the great selling points of London because it has underpinned, I think successfully, the position that up until now at least London has occupied as a financial centre, and particularly for the way in which judges have developed the law and kept apace with the changes over the centuries. And third, and I think this again comes back slightly to Brexit, is trying to ensure that the government of every nation is held to account by making certain it acts within the law. Now, the one thing that's sometimes misunderstood about the rule of law is that people think, well, it implies a rule by lawyers, or that issues that have to be resolved by a legal resolution. But I don't think that one can say for a moment that the rule of law implies the need for a legal resolution of disputes, or for a decision as to what is for legal resolution or for political resolution. It seems to me that what the legislature decides, whether a matter is for a decision by the state or by an individual, can easily be encompassed within the rule of law. But central to the rule of law, and to my second topic, is an independent, apolitical judiciary. And I do stress the word apolitical, because I think a judiciary cannot these days see itself as a judiciary that is apolitical in the sense it has nothing to do with politics, but apolitical in the sense that it doesn't take an issue on political matters, but it has learnt and must learn to continue to work profitably with government and the legislature. It is a subject, I think, that people don't, look into enough, but I shall come back to this in the course of this evening, as to how should the judiciary work with the government, and what are the constraints in cooperation with the government and with the legislature in safeguarding our system and the rule of law. So that's, I think, two of the subjects I wanted to introduce. I just want to pause for one moment because it becomes relevant, I think, to the way in which technology is affecting us. I shall turn to that in a moment. Is just to say a little word, the fact that our concept of the rule of law, and that's what I've been talking about, is to be distinguished sharply, I think, from the rule of law with Chinese characteristics, as we increasingly come to call it. And it seems to me, certainly, I'm sure this isn't the case in this audience, but in an audience in the UK, I don't think they understand sufficiently the rule of law with Chinese characteristics and the potential nature of the competition it poses to our concept of the rule of law. I think, having grown up in a Western society, we tend to think of the rule of law as being what I have described, and not a system that has two central, very different features. And I think we ignore it because we have forgotten how states who have not committed themselves to one system or another do look upon the legal system of a country that appears to be successful and prosperous. And I think we should never forget that when in the mid-19th century Japan was looking for a legal system that it could import and make part of its way of life, it imported the German Civil Code for a reason only that Germany was thought by many to be the most vigorous and prosperous country in Europe with a legal system that was intellectually coherent. But also we tend to forget that in the promotion of the common law across much of the world, it was done through Western-dominated investment and trade. And in both those respects, the domination of trade and investment and the domination and the prosperity that many perceive from China, that one has to recognize that there is an alternative version. And I think that it is important to look at this just for a moment, because I think there are two fundamental characteristics of the rule of law, the Chinese characteristics, that are important to appreciate. The first is that the party is supreme under the Chinese view of the rule of law. It established the state and created the rule of law. And to a Western eye, the supremacy of the party would be the complete antithesis of the rule of law, as it puts the party above the law as applied by the judges, and sees the party, and not the law, as the giver of rights to individuals. Of course, the Chinese will take the view that this was a misconception, as it is the party that embedded the law, and it's the party that created the state, and it's the party that provides the discipline. And it's through party discipline that you have the conditions for security that are established through the Chinese way of doing things. And I think the great contrast is we look, and this is why the role of the judiciary is so central to our concept of the rule of law, to the independence of the judiciary and its political neutrality. Whereas China, the judges are seen as applying the law, but only in a manner consistent with the supremacy of the party. And therefore, that's the principal difference. But secondly, it's seen in China that the rule of law is tempered by the judiciary, by taking a slightly softer edge, or trying to temper matters by promoting settlement or safeguarding social justice, but of course with the overriding caveat that nothing must affect the supremacy of the party. And I think that why I wanted just to those few remarks in relation to China is that this becomes extremely important when we turn to look at the effect of technological change. Now, we've had globalization since the beginning of time when law has been really relevant to the way in which trade has worked. But I think that the digital revolution has changed things much more than is at first sight apparent. First of all, the rapid advance, particularly over the last 10 or so years, has enabled states and, in the West, great corporations to be able to monitor and derive advantages from monitoring the conduct of people that has never before been possible. For example, processing data, while one loses count of the number of trillions terabytes of data that can be collected every day, and how much is put in the clouds, how much can be processed. And it's the ability to process it that seems to me to have provided huge economic power, not only to the state, but to huge companies. Secondly, and to our individual liberties, this is very important, it's the tracking of where an individual goes and what he does through GPS and the increasing accuracy of facial recognition technology. In London, there are roughly 60 cameras per 1,000 of the population. That is more than in Beijing, which has 40, but not quite as many as in Shanghai, which has about 110. And I don't think until you live in a country where the ability to survey what you do is as intense as it is, do you really begin to realize the importance. And until probably 3 or 4 years ago, that was not as serious as it has now become, and I shall return to this later, is the growth of facial recognition technology, which has, over the last 3 or 4 years, become incredibly accurate and does pose a very considerable challenge to our way of life. The third thing that's made a difference, obviously, is the ability to process electronic payments. You may have seen an interview in the Financial Times where the chairman of the Russian Central Bank was able to tell the Financial Times correspondent what he'd had for breakfast in the morning, because that information had been provided straight through to the central bank, no doubt in that particular case deliberately, but it shows the potential. And I think that it enables one to trace payments and know what individuals are doing. And I need say nothing about the fourth aspect of the great change, which is the manipulation of news, which has played, both in the United States and in the United Kingdom, such an important role in our political development. But it does seem to me that the two critical consequences of what has happened is really to emphasize first the huge power that our governments potentially now have, but also large corporations. But secondly, when one looks at the two rival concepts of the rule of law, one does become really concerned about how our concept, if I may call it the Western concept of the rule of law, is so important in the protection in the individual. Now, can I, having introduced the three subjects, turn to the role of the judiciary? And really the question I wanted to ask, is the judiciary capable of measuring up to this change? Maybe it's for a retired judge as a person can afford to ask that sort of question, because he could possibly give the answer no, whereas a serving judge, I could never have done so. But I think that one has got to ask the question, how does the judiciary set about trying to deal with these issues? Assuming, of course, and this is a question I'll try and answer in a minute, that it's for a judge, for the judiciary to do so. But before embarking on that, just one further word, and that's a bit about the position of the judiciary. What I say is, again, as I said at the beginning, drawn essentially from my experience in the UK, but I think is largely reflected across much of Europe and North America. First, it seems to me that the judiciary has, through the numerous charters and other provisions that have conferred fundamental rights on people, have been very active. I'm not entirely sure, and I say this with some hesitation here, that politicians fully understood what they were doing when they created these charters of rights. Sometimes our politicians ask the question, well, why are the judges doing that? To which the riposte is, because you conferred that right and left it to the judges to interpret it. But I do think that the last 20 or so years in the UK has shown the judiciary expanding its role very considerably and largely for the best. More significantly, and this again is underlined as almost as I speak by the judicial review applications made in relation to Brexit, the judicial review has grown exponentially. And although it now plays an important role in environmental protection, almost anything where you feel the government has failed or isn't doing what you want, you go to court. And if you look at what the judiciary has done, on the whole, I think that it has been generally a force for good. In the UK, it's the growth of the law in relation to privacy and the development of rights. But that's one change. I think a second change in the position of the judiciary has been the assumption of a wider role by judges. Although its primary role has always been to decide cases fairly, quickly, give reasoned judgments, etc., I think many now accept that it has a wider role, but it varies from state to state. I think one sees a judge's job is to try and promote access to justice, to try and make certain that procedure is better, that you require an accountability of people who might come in contact with the law, such as the prosecution service or the police, and in following you here, the accountability of the security services for whether they act lawfully or unlawfully, again, is an extraordinary change in the position of the judiciary. And again, I think that change has been for the good. But we have to remember that many have questioned these changes because certainly in North America, in parts of Europe and in the UK, a number think that judges have gone too far. And I think that given some populist governments in the UK, in the US and in Poland, for example, there has been a considerable antipathy towards the judiciary. It is, I think, unfortunate. But it has to be put in context when one judges the role that judges ought to play in relation to the judicial revolution. But on the whole, certainly I think in the UK and much of Europe, and to an extent in North America, the judiciary have in the bank quite a large credit balance. On the whole, I think one stands back and you look across all other bits of society that are involved in the process of government, judges have come out fairly well. They have a high degree of trust. And the question really that I want to pose in analysing the effect of the digital revolution is, have the judges, are they in a position to build on that trust and improve and keep pace with the changes that are being brought about? And I wanted to take, in the time that I have, two quite separate areas to look at. The first is access to justice and equality before the law, and the second is the development of substantive law. Now, it is, I think, if one looks at the system in the UK, and I confine myself to that there is a great deal of difficulty in saying that in the UK people enjoy access to justice. The law is extremely complicated. It's too complex and too costly for most people to understand, and if you don't have access to a lawyer, it may be very difficult. Without the provision of proper legal advice, and we've had a huge cutback in the UK, it's not possible for people to resolve cases without going to court or giving up to completely. Court systems haven't been modernised enough, and I shall come back to the use of IT in that at the moment. But also of importance to my mind is the growth of private dispute resolution. This has occurred with increasing rapidity across much of North America, Europe, and the UK, where the state seems to be walking back from its duty to provide justice and is content to promote mediation other forms of ADR, and in particular now ombudsman services. It is, in a sense, the gradual privatization of parts of our justice system without any real thought as to whether this is overall the direction in which we should be going. And I think in consequence, certainly in the UK, there is a growing perception that outside certain narrow areas, and if you're in commercial life, of course you understand the importance of the law, but for most people, unless it's the criminal courts and possibly the family courts, law, and as delivered in the courts and justice is delivered by judges, is seen as increasingly less important. And therefore there is a risk of the relevance of the judiciary. And I think this impact of change is, in a sense, the way in which the power of the purse has accentuated the power of those who have resources. A very good example drawn from England and Wales is the use of a legal system to silence those who criticize. We've had some very bad cases recently because you have a lot of money, you can use expensive lawyers, the people who you're acting against cannot, in many instances, get legal advice. The power of the purse has become very great, and it's accentuated, certainly again in the UK, is the rule on costs. It is that is one of the strongest deterrents to being able to use the courts to vindicate rights, particularly as costs bear really no proper relationship to proportionality or the ability to pay. And I think that you also see in many types of dispute a move away from the courts. One of the huge areas that has gone completely from the courts in relation to most small disputes are disputes with banks and insurance companies. They've all gone to the Financial Ombudsman Service, and currently there's a proposal, because of these problems with the courts, that small and medium-sized enterprises should be able to go to the Financial Ombudsman and deal in claims where awards in millions of pounds can be made. And this has a profound implication for the role of the judges in society, but also the development of law. And so the question that I first want to turn to ask, before I turn to look at the development of the law, is really, do the judges have a role in trying to do something about it? Now, obviously, many of you would say that this is not the business of the judge. It's the business of the legislature and of the executive. They should be the people who are putting our system for delivering justice in order. They pay for it. They should do it. Should the judges, is it really a matter for the judges? Now, I can again only answer this question by reference to the UK, but I think to the 3 jurisdictions within the UK, everyone would give the same answer: no, this is a matter the judges have to tackle. Why? I think partly it's because they are in part responsible for the mess, and I'll come back to that in relation to procedure in a moment, but also because they really are the people who possess the experience, the expertise, and above all, the leadership that's necessary. Now, in the 3 jurisdictions, there is a difference in approach. In Scotland, because of the way in which the court administration system has been changed, the judges play a much more direct role. In Northern Ireland, the judges, because of the loss of the legislature, again are playing a more important role. And in England and Wales, I think it's happened that they are playing a different role because actually there's no one else who will do it. And in England and Wales, it produces a greater problem because judges have to remain technically not parts of organizations that change things. They act as, quote, observers on boards. But as long as you're at the table, I've never thought it matters as the precise capacity at which you are at that table. Now, what should the judges be doing? And this is where I now return to the importance, I think, of the digital revolution as regards judges. And I just want to take a couple of illustrations in the time that I have. First, one of the key elements of any system of access to justice is, as I've indicated, the importance of advice and independent advice. And also, I think from the work which was mentioned, which I've been doing in Wales, it's become evident that there is what's known as a comorbidity of problems. Someone who has a housing problem or an employment problem or a debt problem may well develop health or other problems. And one of the things that much more could be done, and I'm not sure that we've been active enough in doing this in the UK, is using the digital revolution to try and provide more advice. Certainly, we've encouraged law schools to try and law firms in the bigger cities to try and provide advice using digital technology to people not in London. But this is an area where I believe the judges have to be proactive, is promoting advice, access to advice. Secondly, and this is an area of much greater importance where the judges have to do something soon, and that is modernizing and simplifying our procedure. Lord Woolf did a wonderful job in simplifying our procedure, but within 10 years, the White Book had grown back to its original length. It came down a bit, and now it's gone back to its regional length plus. And the very complex rules that are in place, although they might work for very large cases, are just simply not working. And there is no doubt that we can use and should harness technology. One example that we've been successful about, I think, has been in providing divorce petitions online and also appeals in social security, where you can produce a document which effectively asks questions, and when you answer it in a particular way, takes you to another one, a sort of decision-making tree. And I do believe that this is an area where the judges really do owe a duty to promote, as much as possible, the simplification and digitalization of procedure. More radically, and this may horrify some, is an attempt to try and simplify procedure across the board. So you do not have rules for family cases, rules for administrative law cases, rules for winding up, but you have one uniform set of procedures. When you stand back and think about it, most processes involve starting, answering, managing, deciding, appealing, and executing. There are a whole lot of little bits you have to graft on, but virtually almost every kind of dispute. If you come to that view, then it's much easier to simplify the process. And you can then use code built into the rules to try and make certain the whole process moves more efficiently. Thirdly, and certainly from a rural country like Wales, or large parts of Wales, it's very, very important you bring back local justice. And technology is, again, something one can use. There's obviously the tension between the cost of providing local justice and the benefit of making justice local. But digital technology does enable you to go to a place to hear a case without taking large amounts of paper, or if something isn't available, you can download the file. And secondly, although people have views about the use of video links to examine witnesses, having done it myself quite a lot over the past 18 months or so, I am convinced that it is extremely effective. And certainly, as long as you can be sure there's no one else influencing what's going on in the room, there is no reason why that should not be used. And then embedding a digital system into managing cases, I don't think I could have found anyone in the UK who would go back in the Crown Court to a system where you had paper. It was a bit of a shock at first to get judges used to it, but now no one will go back. And then finally, I think in this area of procedure, is the position of trying to integrate forms of dispute resolution. I imagine it was fairly obvious from the way in which I tendentiously put the point that I personally find the growth of private dispute resolution as an area outside the province of the courts as something that has really not been generally desirable. It is much better if we accept there are some forms of dispute that are much better dealt with by private dispute resolution. But looking at the system as a whole, it seems to me that judges ought to pay much greater interest in trying to integrate the various forms of dispute resolution. Now, this is not popular. Arbitrators don't like it because they think that you're taking away some of their freedom, and certainly interference with the ombudsman is not liked, simply because it either suits a body like the Financial Ombudsman Service or, more importantly, the private providers of online dispute resolution, that judges are kept as far away as possible from the system. But looking at it from the point of view of delivering justice, and looking at it from the point of view of trying to provide an intelligible and comprehensive service for people, surely we ought to look on the provision of justice as something in which the state has a substantial and overall interest, and the judiciary ought to take a much greater interest. Now, is this an easy task for judges? The answer is simple. No. It is not easy to change culture. It is not easy to change the attitude of a government to the way in which judges ought to become involved. Many look back to those days of old where judges didn't involve themselves in this sort of thing and left it to the civil service. The professions at times think, well, if you try and do this, look at the huge investment you're imposing on it. And the judges themselves need a lot of encouragement. But I think it's worth it. And I do think that if you are, as I shall come back to say in a moment, going to try and make the judiciary relevant to society, the first area we really have to look at is making certain we harness the benefits of the digital revolution to ensuring we have a fair and just system that is comprehensive, and that the judiciary takes a lead in this. But now, what about the law? Because that is equally important and is being very significantly affected by the developments in technology. Now, it's true to say that the legislature in many countries has started to grapple with these issues. For example, in Europe particularly, the GDPR, the General Data Protection Regulation, has been moderately effective in at least providing greater safeguards. But it's not easy for a legislature to move in this area, and I think there are two primary constraints. The first is the power of the big players. They are broadly content with the status quo. After all, if you've built a very successful and large business on the existing law, why would you want anyone to change it? And one must therefore, I think, view with very considerable sympathy the difficulty faced by legislators and by government in trying to alter the law so that it brings a better balance. But secondly, I think it's important to appreciate that the pace of change is so enormous that it's difficult for a legislature to keep in pace with it. For example, the GDPR really says nothing about the value of data. It protects privacy, but it doesn't deal with rights and tradable and the tradability of data. Another illustration is our internet platforms. Very little has been done to develop the liability of those who operate internet platforms for what happens on them. And one can go through the whole gamut of things that are happening, blockchain, initial coin offerings within that sphere, access to digital assets, all of these areas where legislative development is slow. Now, I personally would take the view that in this area, there is a risk to judges in developing the law too much on their own, and legislative development would be better. But I think the judiciary have to grasp, if they're to remain relevant and if they're to uphold the rule of law, certain issues. And can I take a couple by way of illustration? One, which is highly topical in the UK at the moment, relates to the disclosure of information contained on mobile phones. Social media now means that people exchange all kinds of information about themselves with other people. And in particular, because each time you buy a new phone, it imports the data from the old one, and the storage capacity has grown, there is now an immense problem with the amount of data that people have, and it can be relevant. Unfortunately, there have been one or two rape cases in the UK where it has transpired that certain things contained in the mobile phone have been said to be relevant. But it's caused an acute problem. First of all, quite naturally, there is an extreme reluctance on the part of complainants to disclose details of their personal life contained on their mobile phone. Second, I think there is a perception by prosecutors that such information provided on mobile phones, which many members of a jury may not have realized actually people put on mobile phones, certainly if they're of a certain age, and that age is not that great, they might be shocked and think this isn't, obviously if someone records this sort of thing, they can't be the victim. And thirdly, and equally seriously, is the huge burden that it's imposed on the police through what we now fancily call digital forensics, but which is in effect examining the contents of the mobile phone. Now, this problem emerged in England and Wales about 6 years ago, and nothing has been done about it, largely because it's difficult to know what to do. There are huge numbers of cases, but it is having a terrible effect on confidence in the justice system. Why is it? It's said that the rate of prosecutions for rape has fallen so severely. And it seems to me that this is an area where we have to begin to address, from the judiciary's point of view, if the politicians won't solve it, it is a problem that, for the good of the justice system, has to be solved. And can I take another illustration, which is surveillance? From the figures that I gave a little earlier, it's quite apparent that we're a very camered country. And with the growth of facial recognition technology, it has become apparent that one needs to look closely. Now, of course, you can say there are huge benefits. You catch the criminals. Indeed, you can maybe substitute, instead of having a ticket to go to somewhere, they let you in by looking at your face, and probably can do so quite accurately. So there are huge benefits. But is there a proper balance drawn? And quite interestingly, about a fortnight ago, in the Divisional Court in the UK, they had to look at the operation of a system by the police. And there's a whole host of regulations that are relevant, but in the end of the day, it came down to a judicial understanding of how did you balance the protection of the individual against the needs of society. And one could go on. I could talk about algorithms in sentencing reports, how you actually have to understand the real worries that can occur if you don't make algorithms public, that you infringe people's intellectual property, and how you properly and fairly deal with rights over data. And I mention all of these because although I hope the legislature will address these issues, in the end the judges have two functions. The first is to act to the extent they can in balancing what are traditional problems for a judge, but secondly, filling in gaps in the law when the legislature fails to operate. And to my mind, therefore, if you look at the position of the judiciary, I do believe that unless, as the judiciary, you tackle the effects of the huge changes that are being brought about, you are going to dissipate the trust the judiciary has grown, and I fear make it less relevant. And I think there are two primary areas, as I've said. First is harnessing the benefits of modern technology to make our court system fairer and better and cheaper. And activism, a terrible word for a judge to use, in this respect is absolutely essential. The judiciary cannot afford to sit back and not use technology to try and improve the way in which justice is delivered. I'm more cautious about developing the law. But again, judges need to understand that the law, that the legislature and the executive will not keep pace, that much of this is traditional judge work. And I only hope that there we will show a proper balance. Because at the end of the day, maintaining trust in the judiciary, maintaining its centrality in the state, in protecting people, is, to my mind, critical in the maintenance of its position. A fair result from the digital revolution, and ultimately the protection of our concept of the rule of law, because surveillance is but one illustration of what would happen if our concept of the rule of law was taken over by someone else's. Thank you.